All right, welcome everyone to CBIA's HR Hotline Live. I'm Diane Mokriski, Employment Counsel here at CBIA. And today we're going to talk about everybody's favorite topic, family and medical leave. This is definitely one of the more common topics that we get questions on. I know it's common for our speakers as well today, so this will be an important issue. So I am joined today by two very talented attorneys from Carmody Torrance Sandak Hennessey, Nick Zaino and Vincent Farisello. Hi, guys.
Hey there.
So Nick and Vincent are both partners at the firm, and they are both practitioners and specialists in employment law. And so they routinely answer questions about all kinds of employment-related questions, including FMLA. So this is, as we said, this is a hotline webinar. So that means the main focus is going to be on your questions that come in live through the Q&A, and we'll do our best to answer those. Before we get to that, though, I guess Nick and Vincent have some slides they're going to go through. This will only be kind of like a basic understanding of what the law is for both federal and state. It's just going to be about the first 10 minutes, so we have a general understanding of what we're talking about, and then we'll move on to the Q&A. So guys, do you want to get started with that?
Sure do. Thanks for that introduction. Thanks for having us. Okay. So yeah.
Sorry about that. We had an issue there. All right, go ahead.
No worries. And I think you did a good job of teeing it up for why we're talking about this topic, but also the format that we're going to get into. And before we get into it, just a brief disclaimer. Of course, the information Nick and I are providing is for educational purposes and general info. Obviously, it's not specific legal advice, nor does it create any attorney-client privilege. But yeah, I think it's because there's varying levels of experience with FMLA, and we, it does make sense for us to do a little bit of level setting on the very basics. And that's because as we get into the weeds, especially through the Q&A, we don't want to lose the forest from the trees. We always want to kind of come back to those basic principles that we start with. And so one thing to recall right off the bat is there are two similar but different laws that really come into play, a federal and a Connecticut law. Both of them are at their essence job protection statutes that allow job protected leave for covered absences. So starting on the federal side, the federal FMLA does three major things. First, it provides eligible employees with unpaid leave from work for either their own serious health condition, to care for certain family members with a serious health condition, or for certain family or military related reasons. And it provides up to 12 weeks of leave for those reasons in a 12-month period, or up to 26 weeks for certain military related leaves. The second thing the statute does is it requires job restoration. That means an employee under the federal law at the expiration of their leave must be restored to the same or an equivalent position when that leave finishes. And third, the law provides stringent protections from retaliation and interference, which means it's illegal to punish, discriminate, or otherwise interfere with someone or discourage them from using leave that they're entitled to under the law. So not all employers are covered, and not all employees are eligible under the federal law. On the employer side, the statute only applies to those employers that have 50 or more employees. And it's 50 or more employees either in that current calendar year or the preceding calendar year. With regard to employees, interestingly, the first question is not whether their leave qualifies, but simply whether they're eligible. And to be eligible under the law, an employee must have been employed for 12 months, must have worked at least 1,250 hours in the prior year, and they must work at a work site where there are 50 or more employees within a 75-mile radius. The key, of course, is to distinguish between employer coverage versus employee eligibility. And I say that because it can be the case where an employer is covered, but an employee is seeking to use leave who isn't yet eligible for benefits. And one final point I'll make about the federal FMLA, unlike, for example, the Americans with Disabilities Act or Connecticut's disability statutes, There is no undue hardship under the FMLA. If an employee is eligible and their need for leave qualifies, the employer must provide the required leave, no matter how much of a headache it might cause. So shifting gears to Connecticut, Connecticut has undergone some really significant changes since passage of the 2019 paid FMLA program. Number one, the program created a new state-administered FMLI program, Family Medical Leave Insurance, which provides a wage replacement benefit for covered workers who qualify for state FMLA leave. And also the statute or the law amended what was Connecticut's then existing FMLA leave law. Now, there's still job protection component under the Connecticut FMLA, but what changed was who was covered and the reasons for leave. Those have expanded under the statute. But one key thing to keep in mind, and this gets lost a lot, there's two different things. There are two different benefits happening under the state law. There's the job protected leave component, which we'll call for shorthand FMLA, and that's administered by employers. That is the employer's obligation, job, duty to administer the job protected leave piece. On the other hand, the FMLI, the wage replacement benefit, that's administered by the Paid Leave Authority, a quasi-public agency established under the statute. So there's a lot of confusion there, and a lot of employers out there think, oh, I know the employee applied to FMLI and I filled out the wage form that they asked me to fill out, so my job is done here, and that's just not the case. The employer's obligation is to continue administering, and that's its own separate set of paperwork, the job protected leave component, separate and distinct from the wage replacement benefits from the state. So who's covered under Connecticut statute? For private employers, it includes any employer, private employer, with at least one employee. And that applies both to the FMLA and the FMLI components. And that's a huge change from what had been the case when it used to, the old Connecticut FMLA only applied to employers with 75 or more employees. So the upshot is it essentially applies to all private employers in the state of Connecticut. Really quickly, for public employers, only covered to the extent that they have what are defined as covered public employees. That includes non-union state employees or unionized state or local employees who have bargained to participate in the program. And the other note I'll make is the program does not apply to private elementary or secondary schools. So covered employees, what about that? Who are covered employees? We know who are covered employers. What about the employees? So starting on the FMLI side, to be eligible, the individual must have earned at least $2,325 of wages in any of the first 4 of the last 5 completed calendar quarters. And the individual must be either currently employed, or if they're unemployed, they were employed at some point during the prior 12 weeks. Or it could also apply to a sole proprietor, someone who's self-employed, if they have chosen to participate in the program. So upshot here is a covered employee for FMLI purposes may be eligible for those benefits even if they're unemployed. Covered employee may be eligible for FMLI benefits also on day 1 of employment. And also those sole proprietors, self-employed folks out there, they can choose to opt in to participate in the program as long as they commit to pay into the program for at least 3 years. So this is one of those places where that fork in the road is important to remember, the difference between FMLA and FMLI. There is a difference between who's covered under each. The eligibility criteria is different. For the leave protection piece, the employee must have been employed by that employer for at least 3 months immediately preceding the request for leave. And so that means that it's theoretically possible that an employee on day 1 of employment may be eligible to apply for the state for wage replacement benefits if they're not able to work for an FMLA qualifying reason. But at that point in time, until the employee has been employed for at least 3 months, the employer does not have an obligation to provide that job protected leave. So that's one place where they don't necessarily perfectly line up. One other point I think is important to make here is both FMLA and FMLI apply to employees who are working in the state of Connecticut. So that means if, for example, you had an employee who lives in Mass and commutes into Connecticut, they would be covered. If, on the other hand, the flip of that, they live in Connecticut but commute over the border to Massachusetts, they would not be covered under Connecticut's FMLA program. So that kind of begs the question, what about employees working remotely? There can be some complicated rules there, and I don't want to get bogged down on them, but the rule of thumb generally is you look to the state where the unemployment insurance withholdings are remitted. If it's Connecticut, then generally they would be covered. So what about benefits? What benefits are provided under the program? A covered employee could be eligible for up to 12 weeks of paid leave during any 12-month period. A covered employee could be eligible for an additional 2 weeks on top of that, so 14 total weeks when leave is due to for the extra 2 weeks for incapacitation from a serious health condition during a pregnancy. So that could be incapacity or serious health condition that either results from the pregnancy or not, could be completely unrelated. And the other point I'd make is in all cases, employers can choose to require that employees use PTO during an unpaid FMLA portion of FMLA leave, as long as the employee can elect to retain at least 2 weeks worth of PTO in their PTO bank. So qualifying reasons for leave, and I'm going to focus on Connecticut because it includes those under federal, but then goes above and beyond. Leave for birth or placement for adoption or foster care with a child, and that includes bonding time. The employee's own serious health condition, caring for a family member with a serious health condition, serving as a bone marrow or organ donor, certain military-related leaves. We talked about the 2 extra weeks for incapacity due to serious health condition during pregnancy, and also up to 12 days of leave for family violence reasons. That's in addition to the 12 weeks for other reasons. So the big news here was the expansion of who counts as a family member. That's one of the things that changed. It used to just be child, or parent, or spouse. Under Connecticut law, it now includes grandparent, grandchild. Connecticut law also has an expanded definition of child, which may apply regardless of age, whereas the federal statute for purposes of looking at child is generally limited to those under 18. The definition of sibling has been added, so siblings, can be covered as family members under Connecticut's FMLA, and they don't need to be siblings by blood, could be by marriage. But the most controversial one is the inclusion of a phrase, anyone else related by blood or affinity whose close association to the employee shows to be equivalent to a covered family member. That essentially means someone that the employee sees or feels is like a father or like a brother or like a child, even though they aren't necessarily that relationship. And so that's a difficult one. And that's also a brand new one under the new statute in Connecticut. So just pulling it all together very quickly on the process, because this is one of those statutes that does require a very specific course of action to happen. The first thing is that the employee must inform the company of the need for leave. That doesn't mean the employee needs to specifically say the word FMLA or use any other magic words. But if the employer knows an employee will be out of work and the reason is something that may qualify, for example, the employee's going out for surgery, the employer needs to initiate that process. Once the employer has that information, within 5 days, they have to provide they have to make a determination whether the employee is eligible for leave. And that's going to go back to that, have they been employed long enough, et cetera. And so they will kick off the process by providing notice of that eligibility and also the terms and conditions of leave if the leave qualifies. The employer can also at that point ask the employee to provide certain certification to help the employer determine the next step, which is whether the leave itself qualifies. And the employee will have a certain period of time, up to 15 days, to provide those certification forms. After the employer has an opportunity to review those forms, to review that information, they then need to make the decision to either designate the leave or not designate the leave under the FMLA. So that's really, like, in a nutshell, the process. Of course, there are more details, and we could, we're happy to get into those through the Q&A. Before we get into the Q&A, just want to let you all know out there that Nick and I are going to be hosting on May 15th a half-day, 3-hour, really in-depth, roll-up-your-sleeves presentation compliance workshop on FMLA. It's going to be in Wallingford at the Hilton Garden Inn. And so we'd invite anyone who could use a tune-up on FMLA to consider attending. And members of CBIA, we are pleased to offer a 15% discount.
All right, 15%. That's not nothing. So if you're CBIA members, check that out. I think that's going to be super helpful, especially anything that we don't get to today. So let's tackle, thanks, Vincent. Let's start tackling these questions. If the reason for leave is covered by both federal and Connecticut FMLA, must we provide the employee all of the notices for both statutes? Who wants to tackle that?
Yeah, I mean, I think the answer would be yes, because they're different. And Connecticut has a requirement that you provide notice to the employee, and so does the Federal Department of Labor. So you really should create, if you're covered under both federal law and Connecticut law, you can do it with one notice that just combines the different elements of both statutes. So take your notice of rights and responsibilities, notice and update it to include Connecticut, the Connecticut FMLA requirements as well.
Yeah, because I mean, keep in mind, whoever asked that question, if you, like, for example, if you only gave the notice that describes federal FMLA, there wouldn't be anything in there about affinity relationships and grandparents and neighbors and stuff like that. So you need information for both. Okay, how about the next one? Is an employee eligible for FMLA leave to care for a new grandchild?
Yeah, I think Vincent answered that in the expanded definition under the Connecticut FMLA, that grandparents and grandchildren are covered family members. And so if either an employee needs time off to care for a grandparent with a serious health condition, they'd be entitled to it. If an employee needs time off to care for a grandchild with a serious health condition, the employee would be entitled to it, but not, it says a new grandchild, so not necessarily just child rearing.
Right. I think that's probably what they're getting at.
Okay. Yeah. So not that, but for any kind of serious health condition that new grandchild might have.
Yeah. So I think an issue that's come up with grandchildren, grandparents taking FMLA leave for the birth of a child, that grandparent would either have to show, tell me if you think, I think you're either going to have to show you're in loco parentis, which means you're kind of in charge of taking care of that child, because the parent is not around, or you have adoption paperwork or legal guardian paperwork. There's got to be some sort of parent relationship in order to get that bonding leave. I think we're talking about bonding leave in this scenario, right? There's a difference between caring for someone with a serious health condition. You only have to be a family member, and a grandchild is enough. But if you're bonding, you really kind of have to be in the parent role. So that's something that the employer wants to clarify from their employee. So Vincent, why don't you tackle this next one? This is your fault that they didn't know what FMLI was. So remind everyone what that is.
So when we say FMLI, we mean Family and Medical Leave Insurance. It is essentially the wage replacement benefit that's available to individuals who are eligible for FMLA, whose leave qualifies for FMLA. it's the pay benefit that they would be able to get from the state of Connecticut. It is separate and distinct from the job protected leave component, which is provided by and administered by the employer.
All right. And you know what? I just realized I forgot to mention one thing. When we were talking about the notices that you have to give to employees, and you have to give both federal and state, if we could throw up in the if we could put up into the chat some links. We have some Labor Department links that I think people would find helpful. Everyone should know that there is a Connecticut FMLA and paid FMLA notice that's required. You provide it to every employee upon hire. And my understanding is that it is not enough to post it. We're not talking about a poster. It's that notice that goes to all your employees. You can email it to everyone, whether they're asking about FMLA or not. And so we'll put that up. That's it. So everyone send that out to all your employees. And then we've got a few others. There's the notice of eligibility, which we'll put up. And that's the paperwork that you give to an employee when it first becomes apparent that they need leave. And then we'll also put up there the medical certification. That's basically the doctor's note that you want to have the employee's doctor fill out. And then the final thing, I think what's the other notice that we were going to put up? Notice of, the designation notice. So once you hear from the employee that they need leave, you've designated, yes, this is going to be FMLA leave. We're going to start counting days. You give them a notice telling them that you are officially designating this leave as FMLA. So those are just some things to check out in the chat, some really useful forms. Okay, let's go on to our next question. If an employee is approved for intermittent leave for their own serious health condition throughout the year, are they still permitted to retain up to 2 weeks of their PTO?
So the answer to that is yes, regardless of the reason or the type of leave they're taking, intermittent, reduced leave schedule, or leave in a block of time. You cannot require employees to deplete all of their PTO. The employee is entitled to retain at least 2 weeks of their accrued PTO.
Okay. So let's do paperwork. When does the paperwork get initiated? Does the employee have to request it, or is my obligation to give it to them? So let's just talk. Do one of you want to talk about how do you start the paperwork and what does that mean?
So kind of going back to that process slide that I had up on the screen, once the employee doesn't have to make any doesn't have to use magical words, doesn't have to reference FMLA, but what they just need to give enough information to put the employer on notice that they may need some leave and it may be covered under FMLA. And so that should, in my mind, that's what triggers the process and what triggers the paperwork. So the first piece in the toolkit that needs to get completed is this. It's called the Notice of Eligibility and Rights and Responsibilities. The employer has up to 5 days when they have notice of that to provide it to the employee. And it basically tells the employee, I understand hopefully in most cases it's very clear. The employee has actually requested what leave they need. Sometimes it's not. Sometimes it's based on just notice of a surgery, or perhaps another example might be recurring absences due to something like migraines that are happening over a period of time. But the employer essentially provides that document, says, hey, you either are or you aren't eligible based on, for example, how long you've been here with the employer. Number two, we may or may not need more information. And so it'll inform the employee if we're going to be requesting the employee to complete any certification documents, including, for example, a medical certification form from the employee's, if we're using the example of an employee's serious health condition, from the employee's physician. And then it'll also give the employee notice about if there is a leave that's designated. Here are going to be the general terms and conditions of that leave. It'll have information about continuation of benefits and those kind of things. From there, assuming the employer does want the employee to provide certification, They would provide that blank certification form to the employee, and the employee would have up to 15 days to complete it and get it returned to the employer. Once it does get returned to the employer can take up to 5 days to review it so that they can make a decision as to whether or not the leave qualifies for FMLA leave. And that could be, of course, in a block of time, or if it's for serious health condition related issues, it can be on an intermittent or reduced schedule leave. So that's kind of a couple other points I think are worth making, because we get these questions sometimes. What if the employer, has information where they believe it could be an FMLA situation, but the employee does not want to use FMLA? So that's a question that comes up. My word of caution to employers there is, hey, you should, it's up to the employer to designate whether the leave qualifies or not. And it would behoove an employer to initiate the process anyway, because if an employer fails to do that, the employee has never really started the clock on the use of that time. And so unless and until the employer designates it as such, the employee who may be taking continuous absences, which may have otherwise counted, that they haven't really started the clock on that. And on top of it, the employee would, if they're absent for reasons that should have been designated as FMLA, they would still nevertheless have the protections under the law, those non-discrimination, non-retaliation, and non-interference protections that I mentioned before. The other key thing I'll say, because there is confusion about this, the employer's role, these documents we're talking about, these forms, these relate to the FMLA half of the equation, the leave component. The FMLI piece, the employee's ability to seek wage replacement benefits, that's between the employee and the state of Connecticut and the administrator, which is AFLAC. An employee who may be eligible for FMLA leave, and if an employer designates it as job protected FMLA leave, the employee does not have any obligation to go apply for the wage replacement benefits, the FMLI payments from the state. It's up to them whether or not they want to do that. But that'll be a process that's administered by the state of Connecticut. There will be one form that AFLAC will ask the employer to complete, and that's a wage verification form. But other than that, that process is separated from the employer.
All right, so on that, looks like Jamie Allen's question, the answer is the employer decides whether an employee qualifies for FMLA, but right. AFLAC and the state of Connecticut decides if they're qualified for FMLI. That's an insurance issue. Correct. Is that fair?
Right. Right.
And I just want to clarify something that was at the end of that question about the paperwork. And I think what the employer was asking was, is my obligation just to tell the employee that FMLA might be something that they want and I'll leave it up to them to request paperwork? Or is it my obligation as the employer, as soon as I hear there might be an issue, do I then have an affirmative obligation to give the paperwork, or can I wait for them to ask for it?
No, I think it's the latter. Go ahead, Vince.
Oh, no, go ahead. Sorry.
No, I was going to say, I think it's the latter. It's once the employer is on notice that the employee is out of work for reasons that may be covered under the FMLA, the employer has a duty to then initiate that process. And so, there's really four documents that you really have to have a good handle on how they operate. One is just an FMLA policy. You should have one in your handbook. You've got to identify what year you're using. You've got to identify your rules about whether you're requiring substitution of paid leave. So 1, you should have a policy. 2, the notice of rights and responsibilities. 3, the medical certification form. And then 4, the designation notice. And so that is a process that you own. You as the employer are responsible for administering FMLA leaves. Forget about the FMLI for a minute. That's like just an insurance program that's run by the state of Connecticut. You help the employee get FMLI benefits, but that's not really your major legal obligation. Your major legal obligation is to designate leaves that qualifies FMLA as FMLA. Because if you don't do that, right, if you say, well, the employee didn't say FMLA, if it turns out the reason they're out of work is for an FMLA reason and you simply didn't designate it or the employee didn't say FMLA, it's still going to be job protected and you may not be able to go back and retroactively designate it. So sort of knowing why employees are out and knowing whether or not it might qualify for FMLA is really important so that you can get that properly designated in all circumstances where it should be designated or could be designated as FMLA.
Yeah, so that question, there's a question a couple down further that says, so what paperwork is required for CT FMLA? I'm familiar for CT FMLI. So if everyone goes into the chat function and you'll see there's the first thing listed is the notice that you provide to everybody so they know their rights. And then there's 3 others after that, like a notice of eligibility, the medical certification, and the designation. Those are 3. There would be potentially others that we didn't include, but if you go to the Connecticut Labor Department website, go to employers, and then FMLA, and then forms, and you'll see all the forms. But these are the most common ones. These are the notice telling the employee you may be eligible. Here's a doctor's note. Here's all the information you need. So that's in response to that question. What about what if the employee does not fill out the paperwork but is out of work for a period of time? Do we qualify them for FMLA? That's a super common question. Yeah, what do you do? The employee's just out. They left before you could get the paperwork. Then what do you do?
Yeah, so what I would say is you'd send them that paperwork in the mail by certified mail, right? They've been out now, let's say it's for more than 3 days, because that could be one type of thing that could constitute a serious health condition. And so you would call them maybe at home, find out what's going on, let them know that you're sending them the FMLA paperwork, you're initiating that process. In that paperwork is going to be, explain to them what they're going to get, the notice of rights and responsibilities, in a medical certification form. Let them know that it's really important that they have their provider fill out that medical certification form, get it back to you within 15 days, and then you go ahead and designate that leave as FMLA. So start it with a phone call, find out how your employee is doing, why they're not at work, and tell them you're going to initiate that FMLA process. And, they are obligated to provide that medical certification form within 15 days. And invariably, the next question is going to be, well, what if they don't get it back to us? What do we do if the employee doesn't return it within 15 days? And so you would, what we would encourage you to do is go back to that employee and say, look, the 15 days has expired. It's critical for us to get that medical certification form back from your provider so we can verify whether or not it's for an FMLA qualifying reason, right? And so if they ultimately just go AWOL and they tell you they're sick, but they don't give you any information to confirm that they're not on workers' comp, there's nothing. They don't provide you just a blanket medical note, like they're just not communicating with you, and you're giving them every opportunity to provide that medical certification form, and they simply do not cooperate, do not respond, then that leave may not be job protected. In other words, it may be subject to your disciplinary process if somebody's out for 3 weeks without providing a medical reason as to why they're out, right? You could take disciplinary action or terminate their employment, but we would want to go through some careful steps before you did that.
Yeah, I think one thing that comes up a lot in this, the MIA employees, sometimes they're in rehab or there's a mental health issue. And so one thing to keep in mind is that you can get that.
Right.
You can receive notice of someone's need for leave from a family member, right? Or from a friend. So if you hear from someone that your employee is in rehab, that's kind of enough, right? To get the ball rolling.
Yes.
And you're still entitled to that paperwork, but you can't just say, well, I didn't hear it from the employee, so I don't know anything for real.
Yeah, you might contact the emergency contact, right? If you require employees to provide one, which is a good idea, and you haven't heard, it's possible they're in rehab, right? Or something's happened. And so you would reach out to the emergency contact and say, I'm trying to get a hold of this employee, So yeah, you want to show that you've done everything you could reasonably do to put that employee on notice.
Here, one other point I would make is use of a medical certification form is optional. It's actually there. It's provided as a tool for the benefit of employers to determine if the employer can't otherwise determine whether leave qualifies. But an employer is not obligated to request it, and an employer could have notice, could have information in other ways to feel comfortable that the leave actually qualifies. And an employer certainly could designate leave. To your, using your example, Diane, if you happen to know for sure, you're reasonably comfortable that someone is, whether it's rehab or even, let's say, a more serious one, someone is perhaps on a ventilator or in a coma or something, and you know that, and you have good information on that, you don't need a med cert form. You can still request one, but you don't need
one. Okay. So let's go on to the next one. What circumstances would qualify for both Connecticut and federal FMLA? There's a lot. So why don't you throw out, give us a few.
So the ones that would qualify for both could be birth of a child or placement of a child for adoption or foster care with the employee, and bonding time with one of those children. An employee's own serious health condition could qualify for both. Caring for a spouse, a parent, or a child with a serious health condition would qualify for both. But Connecticut would allow, leave to care for additional family members on top of that. Certain leaves for the certain military related leaves, like leaves to deal with qualifying exigencies, for active duty call-ups, or caring for certain family members who are injured during the course of active duty, that could qualify for both. Am I missing any there, Nick? That would qualify.
I think it's probably easier to say what's not covered by. So what would be covered? It's the other way.
What would be covered under Connecticut, but not federal? Okay, that would be caring for a grandparent, a grandchild, a sibling who has a serious health condition, or one of those individuals with whom the employee has close affinity. That would not, none of those would qualify for federal. Serving as a bone marrow or organ donor only applies to Connecticut, not federal. The additional 2 weeks for incapacity during pregnancy, that additional 2 weeks is only Connecticut, not federal. 12 days for family violence related leave, that's only Connecticut, not federal.
Nicely done. That was impressive, actually.
I think you got it.
All right, Nick, you want to do workers' comp? I just thought that disappeared, but there was a question about what do you do if FMLA and workers' comp cross over, but then you learned that the claim was denied under workers' comp?
Yeah,
there it is. Does it affect FMLA?
Yeah, no, in short, it doesn't in and of itself, right? Because workers' comp is an insurance program that's administered by your workers' compensation insurance carrier, and they may deny coverage for a whole host of reasons that have nothing to do on whether or not they're qualified under the Connecticut FMLA. So don't let the workers' comp process run your FMLA process. In other words, you run the FMLA process independent of what's happening with workers' comp. Certainly pay attention to it and know what's going on, but whatever is decided on the workers' comp side isn't going to automatically impact your Connecticut FMLA obligations. In other words, the carrier may decide, look, the person's definitely injured. They've got an injury, they've got an illness, but the carrier concludes it didn't arise out of and in the course of employment. And so the workers' comp carrier denies the workers' comp claim. But they clearly have an illness or an injury that qualifies as a serious health condition under the Connecticut FMLA. So you run your Connecticut FMLA, you administer that independent of any insurance, whether it's short-term disability, workers' comp, or the FMLI insurance program. You run your Connecticut FMLA job protection requirements based on what you know from that medical certification form, all the forms that we've been talking about.
Okay. So The next question has to do with forms, but let's just talk about that part that's highlighted. I don't believe there's a form that talks about family members, but do you want to just tell everyone again, in Connecticut, what is a, quote, family member?
So a family member can include, like federal, a spouse, a parent, or a child. It could include a grandparent or a grandchild. It could include siblings, either, and that could include biological siblings, but also half siblings, adopted siblings, etc. It could also include people who are none of those things, but whose relationship with the employee is close enough to be the equivalent of one of those things. So someone who's not related, but is like, for example, a parent, or not related, but like a sibling, or not related, but like a grandparent or grandchild. That's what we refer to as the close affinity category. And that can be difficult because it's hard. How do you confirm that? How do you know that for sure? Well, I can tell you that the Department of Labor has taken the position that the employer has to rely on the certification of the employee in that regard. And so there is a sample form available on the CTDOL website. It's a one-pager. And an employer can use it if they so choose, but you'll see it's very, very simple, and it relies on the employer's certification, their statement that the individual they're claiming to be of close affinity is in fact so. The employer cannot ask for anything more beyond that. Cannot ask for other documentation.
Okay. How about this? Even after providing employees their notice of rights, many employees just don't ever apply. And our program is administered by a vendor. So in those circumstances, is the employer responsible for applying for FMLA on the employee's behalf?
Yeah, so this is, oh, go ahead, Vincent.
No, go ahead, go.
No, what I was going to say is there's a misconception that there's an application process, or that the employee controls whether or not a leave counts as FMLA leave or not. And that's really not accurate. I mean, the regulations say that it is the employer's responsibility to designate leave as FMLA qualifying if it otherwise qualifies as FMLA leave. So it's really not an application process. It's a little bit of an interactive process, because the employee, as Vincent said, needs to give you enough information that it might be covered under the FMLA, whether that's either using the words FMLA, being out for periods of time that may qualify as a serious health condition, right? Once you're on notice that it might be FMLA, that then triggers your responsibility to initiate that process of designating it as FMLA leave. And so at the end of the day, it's either covered in the FMLA or it's not. And that's a decision that the employer makes by getting the necessary medical information from the employee, either through a medical certification form or through other information that the employer receives that allows the employer to safely conclude, yes, this is FMLA. So it's not, don't get tricked into thinking it's an application process or the employee can choose whether or not they want FMLA. It's really an employer obligation to designate it as such when it qualifies.
So I think that answers the next question as well. And Vincent, say what you were going to say as soon as I ask this. So,
oh, sorry, I was just going to make the point. Keep in mind, though, if what Nick just responded to is on the FMLA side of this thing, the FMLI piece, the pay portion of it, that is up to the employee to go and apply for it. That is different than the job protected leave. Can't stress that enough.
And so, Nick, if the employer never does get the medical documentation, even after they've requested it and all the extensions and deadlines have passed, this covers that next question, then is this true? It is not up to the employer to apply for FMLA. You either get the medical documentation or you don't.
Exactly.
Right.
In other words, in that case, if you don't get it, despite your best efforts, you don't get any medical confirmation that the person is out for an FMLA serious health condition, then you would send a designation notice denying that leave, right? And saying you've been out for 3 weeks, 4 weeks, and we haven't gotten any information to confirm that it is for an FMLA qualifying reason, and therefore your request for leave is denied. So that designation notice, there's a box there for that. And you then would say, well, you've now been out for 4 weeks, way above and beyond what we provide as any kind of PTO or approved unpaid leave, and therefore you're subject to disciplinary action.
Okay. So how about the next one? Can you run CT FMLA and federal FMLA concurrently?
Yes, you can, as long as the reason for the leave qualifies under both. So if it's the employee's own serious health condition, for example, or if it's to care for a family member that's covered by federal and state law, or if it's bonding for after the birth of a child, any of those things that qualify for both, you can absolutely, and we would recommend that you do run them concurrently. The difficulty, of course, is there could be circumstances where an employee is at that time eligible only for one federal or state, or maybe it's the reason for leave is only covered by, for example, state. So there are circumstances in which you cannot run them concurrently because it might not, both might not apply. But whenever they do, you can and you should run them concurrently.
Okay. So this next question from Anonymous having to do, I'll read it, but I have an employee that's absent every week due to health issues. The employee provided doctor's notes, so I offered Connecticut Paid FMLA. Is that correct process? We're under 50. I think what I'd like to do in response to that one is not go to that question, because that is I think that attendee needs to go back to the beginning, maybe look at the slides. Under 50 employees that's not a thing anymore, right? So go back, look at the slides that Nick and Vincent showed in the beginning, and you'll see that paid FMLA is something that the state does, and CT FMLA is something that you as the employer does. And if that doesn't answer your questions, to go back to the beginning and look at the slides and rewatch the webinar, you should go to Nick and Vincent's event on FMLA, which we will tell you the data. Why don't you just say that right now? Tell everyone again, when is your FMLA
Sure.
seminar?
It's going to be May 15th, and it's going to run from 8:30 a.m. to 12 p.m., and it'll be at the Hilton Garden Inn in Wallingford, Connecticut.
Okay, great. And so we did the FMLA. Okay, this isn't quite the same question. Can FMLA and CT paid family leave run concurrently for the same issue?
So I think it's a similar answer, if it's kind of the same answer. But
yes.
I'll throw one monkey wrench out there. Remember what I said, that you could be eligible for FMLI on day one of employment, but not, and that's the wage replacement benefit, but not be eligible for job protected leave under Connecticut FMLA for 3 months. So there could even be circumstances where the pay benefit from the state doesn't exactly line up with the job protected leave component provided by the employer. Those situations are kind of few and far between, and probably count on one hand how many of those I've had.
Okay. So is CT FMLI just another name for Connecticut paid medical leave? Yes.
Yeah.
It's another name for Connecticut paid family and medical leave. For a second there, I thought they were going to talk about Connecticut sick leave, which is something totally different. But
yes.
All right. Is there someone that is available on hand to help us fill out the FMLI forms? Okay, go ahead, Vincent.
So yeah, I mean, it's something that we have to help our clients with every now and then. More so on the FMLA piece of it. On the FMLI piece, that's the wage. I think the name of it is a wage verification form. It can get complicated, especially if you have folks who don't work the same schedule or who have alternative forms of compensation like commission and whatnot. But yeah, to the extent you need help, Nick and I are here. And like I said, it's a service that we do provide to our clients.
Also, I think in this scenario where they believe they filled it out incorrectly, and so the employee was denied, you could also contact the Paid Leave Authority and go to their website. Their contact information is on their website. And if you have a case number in particular, which you will if you got paperwork, they'll help you with that as well and see if you actually did fill it out incorrectly and help you correct that problem. All right, Nick, what happens when an employee doesn't return a med cert form within 15 days? Then what do you do?
Yeah, so again, we would encourage you to send something out in writing by certified mail or email, something where you can definitely confirm that the employee got it to the best you're able to do that. Letting them know that the med cert form was back. It was due back within the X date. They failed to provide it. You'll provide an additional grace period, let's say an additional 7 days, just as an additional grace period for the person to send back that med cert form, and let them know if they do not do that, you will not designate that time off as FMLA qualifying, and therefore that time that they're out of work, again, assuming you don't have any information to confirm that it's for a medical reason, right? They just literally went AWOL on you and are not communicating. You tried their emergency contact, they're not communicating. You've done all those things you can reasonably do to find out why they're out and they're just not responding. Then you would send them a letter. If they don't respond again within 7 days, you would deny that leave and you'd send out a designation notice saying it's denied, and then it'd be subject to disciplinary action.
All right, so how does the employer determine whether or not to offer FMLA leave or short-term disability?
I don't know that the employer needs to make that determination. I mean, STD, in the most general sense, is a voluntary insurance benefit that an employer has elected to purchase, whereas your FMLA obligations are required under law. And the two things could interact with each other, could overlap, should work with each other, but they're separate. And if you happen to offer STD, don't think that by just offering someone STD, giving them the application, helping them go get STD benefits relieves you of your obligation to do the FMLA process, if that also applies.
Yeah, because you might get both.
Yeah,
right?
Could get both.
Yeah,
absolutely. Yeah. And in Connecticut now, since the FMLI program has gone online, most STD plans have been rewritten, redesigned so that they specifically work with the FMLI program. So there will be coordination that may depend on your specific policy, but yeah, you should be doing both.
All right, so this relates to that issue where your employee is absent before you really learn anything or get the notice. So what if the employee is in the hospital? Does the notice of eligibility start when they were admitted to the hospital or when you learned that they were in the hospital?
It goes from the date that the employer was made aware that the employee may need, would be needing FMLA. So, go ahead.
I was just going to say, yeah, I think if you look at the notice of eligibility, there's actually 2 different dates on there to fill out, right? It starts out like on X date, I learned that you might need leave. So you fill out that date, the date that you learned. Then there's another section that says, I learned that you may need leave beginning on, and that'll be a different date, like the date you were first absent from work, basically, right?
Right, exactly.
Well, yeah, it'll be helpful to kind of just use that form for that for that. All right, we have an employee whose PCP put 9 different unrelated conditions the employee may have to be absent for. Okay, can or should we push back? They're out frequently, intermittently. Who'd like that?
Well, the doctor or the primary care physician or the provider or healthcare provider really just needs to identify that one of the 9 is for a serious health condition. And so they need to check the appropriate box. So we'd have to look at that form to really figure out if that form has been properly completed by that healthcare provider. And if the answer is yes, it doesn't matter if it's 1 or 9. But that just depends on how it's filled out, I think, and what the provider is saying on that medical certification form.
Yeah, that sounds like a question. I think it's a common frustration. I think that people feel that employees, doctors are kind of just trying to do them a favor, and they're throwing a whole bunch of stuff on the doctor's note, and it's some of it may be BS, and so everyone's frustrated. But yeah, it really is just going to come down to like, just does one of those conditions satisfy what we need? And that's all that really matters. All right. And so we've touched on this. If an employee doesn't provide the certification, can you deny leave? Yes. Although, do you want to touch on when are the circumstances when you actually don't need a medical certification? Right? Like,
you don't need one for pregnancy if it's just straight up for pregnancy. You don't need one for bonding, for child birth or placement or adoption or foster care. I don't think you. Oh, go ahead.
Yeah. So I was just going to say. So yeah, like if there's a father who wants to bond, you don't need any doctor's note. The father's not sick and the baby's not sick. So right. Yeah.
Correct.
Okay. How about if an employee applies for caregiver leave at the end of the year and gets it, and it runs into the new year, and then it ends. If the employee needs it again for a reoccurrence for caregiver leave, does it count toward the same leave, or is it different because of the new year?
Well, under the law, the employer gets to choose the 12-month period for which an employee can use their 12 weeks of leave. Employers can choose to do it on a calendar year basis, i.e. Jan 1 to December 31. They can do it on a fiscal year basis, anniversary year basis, or they could also do it on a rolling look back period. You could do a rolling period as well. But going to the caregiver leave component, I'm not sure if they mean bonding with a child, or if they with a newly born or newly placed child, or if they mean caring for a family member with a serious health condition. I draw that distinction because if we're talking about bonding, there is the limit there to use it within 12 months of the birth or the placement of the child. So that's one consideration to take into account. The other is what is the employer's measuring stick for the 12-month period? If using this example, the employer happened to be doing a calendar year basis, and the employee, for example, started caring for a family member with a serious health condition December 1st, for example, and they used up 4.5 weeks, and it goes to the new year, that restarts that 12-month period, they could theoretically be eligible for 12 more weeks again. If, on the other hand, the employer has decided to do, say, a rolling period, then they likely would not be eligible for caregiver leave again until the next 12-month period rolls around.
All right, so we're actually at the end of the hour, but just because I wonder if you can just clarify this relatively quickly. So this is a question up the top. So essentially, FMLA protects your job, and FMLI provides income. So far, so good. But they can't be used at the same time?
No, they usually are happening at the same time. And we're in 9 out of 10 times, well, don't quote the statistic, but in most cases, they are running at the same time.
Yeah, there's a few, what's the word I'm looking for? Unusual circumstances, when they won't be at the same time, but they're usually at the same time.
Correct.
So we've got a lot of questions remaining, which clearly we could go on for hours and hours with all these questions. So we are so appreciative that everyone attended today, but it looks like you all need to go to the follow-up seminar. You guys aren't calling it a seminar. What do you, a workshop you call it? So you're
Yeah.
really going to like get down to the down and dirty on this. So tell everyone one more time about this workshop. There's a deal for CBIA members. So remind everyone when that is.
Sure. It's going to be May 15th, and it's going to be from 8:30 a.m. to 12 p.m. So it's a half day, 3-hour plus workshop. And it will be at the Hilton Garden Inn in Wallingford, Connecticut. And yes, we are offering a 15% discount to members of CBIA. If you can register to attend at our website, carmodylaw.com, or you can go to eventbrite.com and search Carmody Torrance. And if you'd like to apply the discount code, it is CBIA 2024. Or you can just reach out to Nick or I, and we will help you, help direct you.
Okay. And as always, if you are a member, you can reach out to me as well. So thank you, everyone, again. Thank you, Nick and Vincent, as always, for your help during our hotlines. And we hope everyone has a great afternoon and good luck with your FMLA.
Thanks,
Bye,
Diane.
everybody.
Bye, everyone.
Thanks, guys.